Jack Smith filed a blockbuster motion today in the Tanya Chutkan, Washington, D.C. Election stealing Jan 6th case against Donald Trump. And this is a motion that he's required to file by law if he wants to introduce any evidence of any uncharged or prior bad acts, any uncharged crimes or prior bad acts that aren't in the indictment. So in the indictment, really, the way it works at any trial is you're limited by the charges. You're limited as a prosecutor in terms of what you can bring in, and you're limited, obviously, by the charges and the elements of the crime. You're not allowed to bring in, for example, prior crimes that you've committed, right? Because that could show a propensity that you are someone who commits crimes. You're someone who's a criminal. That's obviously relevant, but they will say that's overly prejudicial because just because you're a serial burglar doesn't mean you committed this burglary. And the people still have to prove it beyond a reasonable doubt, or the government. And so as a result, prior bad acts or prior crimes evidence typically does not come in unless it fits within a certain narrow category called 404B federally, or in the state we call it Molyneux evidence, Molineaux, the French spelling. And that's after a case where Molyneux was the defendant. Anyway, so really the exception to this rule is if the prior bad act, and it doesn't have to be a crime, it could just be something that you did that could be prejudicial or makes you look bad, frankly. It comes in if it tends to fit into an exception. And the exception is whether or not it goes to motive, right? Does it show that your motive to commit the crime? Does it show the intent to commit the crime? Does it go towards that? Does it go towards like a common scheme or plan? In other words, do you have like a signature to your crime? You know, do you always do something a certain way? So it shows that you used that same signature, if you will, to commit the crime. Or does it show your plan, right? So there's certain exceptions that allow it in. And Jack Smith, that's what he did today, was he broke it down by various categories and talked about the evidence he wants to bring in and the exception that it falls under and why it should come in as 404B evidence. And that's from Federal Rule of Evidence 404B. That's where it comes in. And this is entirely discretionary. The judge can decide whether or not it comes in. So this will be up to Tanya Chutkan, and it's not something that they can appeal in the middle of the trial, right? Like right now they're appealing the presidential immunity question, which is something that you are allowed to appeal mid-trial. And that actually could delay the trial from going March 4th if the Supreme Court decides to hear that or decides to press pause on the trial going. But this is the kind of thing that you can only appeal after the fact if you're convicted, right? When it goes up on appeal. So this is not something, whatever Judge Chutkan rules here, it will happen and it will come in at the trial. So one of the categories that Jack Smith talked about, and he broke them down into a couple of different subsections, but in this motion, he basically said, look, we're going to give extensive advance notice of all of the intrinsic evidence, meaning the evidence within the indictment that the government plans to introduce at trial, including exhibits, witness lists, motions in limine, which means pretrial motions, and a detailed trial brief setting forth the government's planned trial presentation. That's all over and above what Jack Smith is required to provide, right? Some of it you have to provide ahead of time, but he's going to give all of this way in advance. He's basically going to say, we are going to give you a roadmap to all of our evidence, all of our witnesses, and a script, essentially, of what to expect at the trial. But in the abundance of caution, he says, we are going to also tell you about the evidence that this evidence in this motion, this 404B motion, although we think it's intrinsic to the charged crimes, meaning it's part of it, some of it either predates the period of the conspiracy or postdates it. And so if the court finds that it's extrinsic, meaning it's outside the conspiracy, then we're going to do this as a 404B motion. And just to be clear, it's not being offered to show criminal propensity, but it's to establish Trump's motive, intent, preparation, knowledge, and absence of mistake, and common scheme or plan. Don't forget, this is the case where Donald Trump is the only defendant. There are unindicted co-conspirators also discussed in the indictment, but he's the only defendant. It's 4 charges, and it's a very short conspiracy. It's November 20th of 2020 to January of, I think it's January 17th of 2021. It's a very narrow period that he alleges in the indictment. So some of this comes back, dates back before and after that, and he wants it to come in for the reasons that we just said. And so there's one category that he called, but it's all the historical evidence of defendant claiming election fraud. All the stuff that went on prior to November 2020 of defendant, that he has a history and a consistent history of claiming that it was election fraud. And Jack Smith cites lots of examples such as, first he starts with saying, look, the defendant's conspiracies relied on knowingly false claims of election fraud, right? That's sort of in the indictment. And so Jack Smith wants to introduce a number of public statements by the defendant in advance of the charged conspiracies claiming there'd be fraud in 2020, right? How would he know? It hadn't happened yet. And that by making these statements, he sowed mistrust in the results with the American people. And this historical record of making these claims is something that Jack Smith the special counsel's office wants to introduce. So, for example, in November of 2012, like a long time ago, right? A good many, many years before all of this, before 2020. So 8 years prior, in November 2012, he issued a tweet, saying voting machines switched votes from Mitt Romney to Obama. Okay, that's in 2012. He wasn't a candidate then, and he's already saying that. Where did he base that from? But he's already kind of sowing that distrust. And then in 2016, the presidential campaign, he repeatedly claimed with no basis that there was widespread voter fraud. And both he and his co-conspirators made statements, issued tweets, and said things like, of course there's large-scale fraud happening on and before Election Day. Why do Republican leaders deny what's going on? Why are they so naive? That was a tweet. And, he also talked about things like, that he wasn't going to, prior to all of this, he wasn't going to commit to a peaceful transition of power, right? He talked about, he wanted to, Jack Smith says in order to ensure the destabilizing impact of his widespread election fraud claims in the run-up to 2020, he repeatedly refused to commit to a peaceful transfer of power, right? And it showed that he planned on remaining in power at any cost. And he cited a news conference in 2020 in September where he was asked, whether win, lose, or draw, in light of, rioting that's happening in many cities across the country, both red and blue states, would you commit to a peaceful transfer of power after the election? And he hedged, right? We're going to have to see what happens. I've been complaining strongly about the ballots. They're a disaster. And the reporter said, but there's rioting. Do you commit to the peaceful transfer? And he's like, I know, but there's a problem. The ballots are out of control. And same thing in a debate in October of 2016 when he was asked whether he would accept the results of the election, and he said he'll look at it at the time. And the moderator is like, wait a minute, there's always been a peaceful transition of power. Our country prides itself on this, and it's for the good of the country. And he's like, I'll tell you at the time. I'm going to keep you in suspense. And look, Jack Smith, I think, did a really good job at showing how all of this goes to his motive. Right? He was going to take this election no matter what. He was going to say he won and try to stay in power no matter what. Right? He's been saying it all along, and all these statements go towards that. It also goes to his intent, right? It shows he intended to do this, and it goes to his plan, right? This was a plan. This was an absolute well thought out plan with lots and lots of co-conspirators and other people who are there to enable this plan. And so this motion, I think this category of evidence of past knowledge and past intention, I think is absolutely going to come in. And I don't think Jack Smith and the special counsel's office is going to have a problem with that. And I think Judge Tanya Chutkan is going to rule in his favor with that category of evidence. I'm Karen Friedman Agnifilo, Legal AF. Join me every Wednesday and Friday. Thank you so much for listening.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.